My name was taken as Jawad, Sarwana, Jawadul Hassan, because what I did for mediation, Jawad Sarwana did something, so people start calling me Jawad Sarwana. So my name has now become Jawad Sarwana because he's a leader in mediation. My task today is to wake you up because it takes you 10 minutes to digest the food and sleep. So I'll take 10 minutes, 5 more minutes to wake you up with a success story of 5 months in 5 minutes. How we developed a concept of mandatory mediation, followed with respect, acknowledged by the West, followed by judges in Pakistan. We have got all the booklets with all the judgments. But what made me do that, the topic is mediation for black. Justice Bashir Alam Saab, when we started this movement 5 months ago, he came to the Pindi bench and said, when I started the mediation concept, वकीलों ने उखाड़ दिए थे stages को. उन्होंने कहा खबरदार हमने शुरू नहीं करने देनी. This is something which they never liked. I was a corporate lawyer. I used to do a lot of cases in London, ICC. I also never liked mediation, but since what made me realize for mediation is the tool. Mediation is something very successful. We have an ecosystem we have developed so far, and I must acknowledge Sindh High Court with CIRB that they have brought the entire ecosystem of Pakistan under one roof today. The ecosystem consists of the superior court judges. The ecosystem consists of the lawyers who have been appearing in all the cases which I refer. The ecosystems have the district judiciary, the vision of the Chief Justice of Sindh High Court, and Justice Nan was mentioning me today. They included the entire judges because centers can come and go, but if the judges are not there, and the judges are the main player, the critical, interdependent, and symbiotic relationship with the judiciary. If judiciary likes Justice Jawad Sarwana, if judges like us, and judges who, because laws has been there, what I will start is 5 days ago, biggest corporate dispute in India was resolved through mediation. How we resolve corporate disputes in a big family matter, I decided a corporate dispute, and I appointed Justice Jilani last week in a very big family matter. Justice Shahid Karim, a very renowned family matter, appointed Justice Khilji Arif, and Justice, you appointed Khilji Arif, and Justice Shahid Karim appointed Justice Bashir Alam Saab. In a very big matter, he's doing an arbitration mediation in Lahore. What happens to India and why they are successful is the Godrej family, 120 years old, is now safe. The family of Ambani, the family of Tata, the family of even Nulsi Wadia, the grandson of Justice Jinnah, he had the issue solved through a mediation in Mumbai. Lawyers thought, what we are thinking now, they thought 10 years ago. The Parsi community sat down and saved a big, huge family concern of cases. What is mediation for Pakistan? The approach is, which I learned while sitting as a judge in London last year with Justice Lord Lady Suker, the Chief Justice of England, and Master of Rolls, Justice Geoffrey Wachs. They said to me, well, we are going to now resolve 10 years issue of can a court direct a party for mandatory mediation without the consent. Because the Hillsley judgment 2004, England and Wales Court of Appeal, page 142, was saying, no, I paid the tax, I hired the lawyer, and I want a decision by a judge. That was overruled by James Churchill versus County of Wales, 2023, England and Wales Court of Appeal, page 1416, that says court can direct. Same day, a case came to me, and I was hearing a case, and Mr. Ahmed Bilal Sufi was the counsel in that case. A big matter came to us. What we thought that, can I do a mediation in Pakistan? There are laws, I know, 89 CPC. There are laws, income tax laws, I know. There are provision in the law, but can I make a first jump? I never realized that my jump, which I jumped first time in 2024 CLD page 1, would have been accepted, followed, relied, and respected by other courts, not in Pakistan also across the border. The jump was very easy. A jump was very easy. I'll explain that to you, that we need to jump unless we know 4 core areas. First core areas was, we need to strengthen the regulator. The concept of regulator. In SCCP 2021 CLD, page 931, we had to build what SCCP is and how it as a regulator can do a regulatory mediation. Because most of the cases coming to us is an issue between, which is against the SCCP or a shareholder. Or some State Bank 2023 Lahore, page 380, where we held that State Bank is a regulator. Justice Jawad Usmani is sitting here, who is now the State Bank, when the judgment of the State Bank was declaring State Bank as a regulator. When the regulator acts as a regulator, most of issues will not be coming to court. So once we set up the commercial courts in Punjab, Justice Shah mentioned when we were launching the arbitration law last week, we also mentioned that we need to have the commercial court, because we attended the commercial court conference of the judges, and Punjab had the commercial court, and they were acknowledged by that Pizza Hut judgment 2021 CLD, page 639, stating that it's the ease of doing business. Pakistan needs to improve its ranking of business in doing it. And commercial court is a main commercial component for international dispute to be resolved. Then Justice Yusuf Saeed in G.A. Pathan versus Federation of Pakistan, PLD 2023, Sindh, page 781, has then developed the concept of commercial courts in Sindh. So something I want to share with you by pausing for a minute. Pakistan judiciary is united. Pakistan judiciary is together. Pakistan judiciary is there for the issues of dispute resolution. On a Saturday, the entire superior judiciary with the district judiciary is sitting with us. When I was speaking to the launch in IBA last week, I said to the businessmen, the entire business community with IBA was sitting there, that on Friday afternoon, we are not playing golf, we're not on a boat. We are all sitting for 4 hours to learn and resolve the issue of 60% of Pakistan commercial hub. It looks good internationally. That is what Pakistan needs today, because we are sitting and speaking and standing in the city, Karachi. The entire commercial law was built up by the Sindh High Court. I must acknowledge the role of Uzeen case, Okhart case, biggest cases in arbitration where courts were mentioning less intervention in the arbitration, the concept of venue changing to Pakistan, the concept of saving the cost in the international arbitration by Justice Nasrul Mulk, Justice Ajmal Mia Sahab, Nasir Aslam Zahid Sahab, Salim Asriki Sahab, Salim Akhtar Sahab. And only way that the most cited judgment per day by 117 judges of the High Court, 4,200 judges of the whole Pakistan, 5 provinces, various districts is Shala Zia Wabda by against Justice Salim Akhtar, PID 94, Supreme Court 693. Different things, that judgment has different flavors to it. Their judgment is the first judgment in the world which says that soft law can be made hard law if it's enunciated in the Supreme Court judgment, because what the whole judges, judiciary are hearing, the district judiciary, Pakistan has a very unique constitution. Article 189 clearly states that the judgment of the Supreme Court enunciates a principle of law and decides a question of law. It shall be binding on the courts below. And the judgments which we are giving from the high courts and all with the issue of ADR and mediation, there is subject to Article 189, a high court decides the question of law. And then the district judges who are hearing today, sitting with us, will be, what is the way forward? That is what I wanted to say. So issue is, what happened to that case? A case came to a corporate dispute. I thought, what can I do? I looked at the preamble of the company law. Preamble gives me an opening which says, whereas it is provided for the effectuous resolution of corporate dispute. Then I touched upon the matter was before me under chapter 9 of 286. But when I examined chapter 8 of the Companies Act, that gives me a straight indirect provision of mediation by the commission. It says commission can mediate a matter. Commission can refer a matter for mediation. I'm not a commission. So what I held in 2004, 24 CLD page 1, if a law empowers a government functionary to get the notification to a high court judge, because I act as a company judge and I act as a merger judge. Merger position is not with us under 284 of the Companies Act. It is the commission which is given through the section of the Ministry of Finance. If you give me the power, I can take the power. The power of the commission can be a power of the court. And the power of the court is to mandate a party for a mandatory mediation. The word used, mandatory mediation, what Churchill said. I'm not going to ask you. What concept was in the mandatory mediation is the concept of ENE, a new concept called early neutral party evaluation. In all corporate disputes in the world, judges, a commercial side, they say, I am referring a matter to ENE, which is you evaluate your case, and if it is successful, go for mediation, and if you failed, then I will go to another term called time-specific, time-bound company law section 6. In one of the judgments I held in Lieutenant General Mahmood Akhtar versus SCCP 2022 CLD page 718, that company law states any company petition filed before the company judge, there is a case management plan and a case management conference, and the parties are directed to file its reply, and the court shall not exceed 120 days in the company petition. This is the commerce of Pakistan. So that is if he fails. So what in that judgment we examined and looked into is that we examined that a court can direct, and court directed, parties sat down. In the 5th meeting, they came and said, we are settled the amount. That judgment came in November, and the story goes on that why did I do it? I had to do it because I saw Justice Iftikhar Chaudhry's judgment of Atak Oil 2007 SCMR page 905 indirectly mentioning mediation in the opta dicta part. Then I found the judgment of Justice Munib Akhtar 2012 Sindh page 388, the case of Asif Shahjani, where my lord mentioned mediation in state decisis. But I never had a judgment on a ratio descendi on mediation. So you have to look into judgments of the courts which were mentioning mediation but not directing mediation. So what we did was, we from the opta dicta, from the state decisis, we came to this point, and luckily then Justice Yusuf Saeed was the first judge to adopt this thing, that approach in a very famous case of Sindh High Court. A suit was pending before his lordship, and then that case was Sajjad Arshad versus Pervez Arshad, suit number 1721 of 2022, where that was referred to a mediation, and Justice Khilji Arif is doing that mediation. Then Justice Shahid Kareem, they gave the mediation by appointing Justice Mashir Alam Sahab. Then Justice Masoodi Shah, in the 2 recent judgments of Sindh High Court, or Supreme Court of Pakistan, in 2024, Supreme Court of Pakistan, page 123, has given the whole concept of what mediation is, how pro-mediation bias is to be approached taken by the Supreme Court, and then he referred his earlier judgment of RYK versus Federation of Pakistan, 2023 SCMR, page 1856, where my lord has mentioned what the ADR show cause is akin to a mediation. So I wanted to share with you, since morning we've been discussing here, that what Pakistan judiciary has done, and I want to end up in saying the conference is on the concept of dispute, and Pakistan looks good. Judges, all judges have done great work in mediation, but we started by Justice Jawad Sarwana Sahab. मुझे भी सारे सरवाना साना ही कह रहे हैं आज, तो मेरा नाम पढ़ भी जाना है, मेरा नाम कभी कोई और लेता है, उल हसन आया, कभी जवाद ख्वाजा साहब, मुझे वैसा नाम मेरा कभी किसी ने ठीक लिया ही नहीं किसी कॉन्फ्रेंस में. I never been taken a straight name because all my names have been ul or ख्वाजा or sarwana. Today I got a 3rd, 4th name today. So anyways, I end up with this saying that Pakistan ecosystem on mediation has been strengthened. This is the efforts of Sindh High Court, and all judges sitting with us, everybody has contributed. Even the Peshawar High Court, Justice Jawad Sahab is sitting here, he was the first one to give a first judgment on foreign arbitration of SAF power case. And every province has contributed everything to High Court in various ways. Even Adnan Sahab is sitting here, Mashir Alam Sahab, Khilji Sahab, everybody has contributed to a lot in Pakistan. And we must thank the judges sitting with us today, who are a future of Pakistan, and judiciary is united. Thank you.